Good morning, everyone. Today is July 10th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Uh, this is a fundraiser for food banks. There's no charge for this great webinar. We're live every Thursday morning with another exciting episode for mediators, arbitrators, lawyers, and everybody who negotiates. As I mentioned, there's no charge. We ask people to contribute to a food bank if they like what they see. And every week, one of my favorite parts of the program is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers since we began the series 5 years ago. Jean Lawler, would you please do the honors?
Hi, good morning, good afternoon, good evening, everyone, no matter where you are in this world. We're thrilled to say that as of today, we have been told about donations to various food banks around the world in the amount of $834,746.57. I can see that $1 million. I know I say that every time, but it's a coming. It'll be here soon. And so 834,000, wow, that's millions and millions of meals. So thank you all so much for your generosity. Same time, same place, every week. And as much as you can give of yourself, of your treasure, your time, whatever, it is most appreciated. But please let us know so we can add it to our running total. Thanks so much.
Thank you, Jean, and thanks to all of you who have contributed and to our great speakers in whose honor those contributions have been made. Today we have another great speaker, one of the most well-liked, one of the most highly regarded, I would say one of the most beloved figures in the world of alternative dispute resolution, John Lande, Isidor Loeb Professor Emeritus of the University of Missouri School of Law. I don't know anybody who doesn't absolutely just love John Lande. And today he's going to talk about the many ways that AI can help mediators. John will explain why he developed the Real Practice Systems Coach, RPS Coach AI tool, and how it can help mediators, lawyers, and parties in mediation. Mediators understandably focus on what to do when parties won't consider reasonable options or engage constructively during mediations. John believes that AI tools can help mediators brainstorm ideas in real time. The tools can also be very useful before sessions by helping mediators prepare, and after they end by helping them reflect on their experiences to improve their techniques. One of the best ways to improve mediation is to arrange for lawyers and parties to arrive well prepared and ready to think flexibly. We're going to discuss how AI tools like RPS Coach can help you prepare for mediation and participate effectively during mediation sessions. John Lande, please tell us a word or two about the food bank to which you would like people to contribute if they're in a position to do so. And then on with your presentation, my friend. The floor is yours.
Wow. Well, I've gotten some wonderful introductions before, but you've topped them all, Jeff. I don't know that anyone has said that I'm beloved by everyone, which hopefully is true. And in any case, I'm not going to argue with you. Um, I confess that until you approached me about this, I didn't think very much, or even wasn't, food banks weren't on my radar. And so I've learned a little bit about them since you've approached me about this, and it's just very touching that people are focused on that generally, and that your program and that Natalie and all of the folks who have organized this are doing it. And have to say, I don't know much about the local one. I'm going to put a link in the chat to the local one. What I think about is my wife, who volunteers for Meals on Wheels, which is another program to help people who are in need. And unfortunately, there are a lot of people who are in need for taking care of basic human needs. And so I think that it's terrific, and I applaud you for that. With that, I'm going to shift gears to start my presentation. And what I'm going to do is I'm going to upload into the chat the PowerPoint, and of course I'm going to walk through it, but it's got some links that you may want to check out. So there you go, and you can check out the links eventually. But now I'm going to share my screen and go to the PowerPoint. And is this now visible to you all?
Yes.
All right. All right. So I'm going to thank you all for, and particularly Jeff, for inviting me. What I'm going to do is go through as quickly as I can a description of this real practice system theory that I've developed. And then based on that, this tool, this AI tool, the RPS Coach. And then the best part will be we'll do a demonstration of the tool. Jeff has developed a hypo of a case, and we'll use that to start off to show you how this can work. And as I say, I've uploaded a copy of the PowerPoint in the chat, which has numbers of links. And if you're like students, you would definitely want to take notes, but you don't have to take notes because I've just uploaded it. A little background about me. And again, I'm going to be talking fast because I want to get to the demonstration part. So if I'm going too fast, hopefully that won't be a problem and you'll let me know. Got a law degree in 1980. In the mid 1980s, I had a law and mediation practice for 2 years. I worked as a lawyer and realized that that was not my best skill. And then I took a training with Gary Friedman up in Mill Valley, and mediation was my skill and heart. And I practiced that for a while. And eventually I got a PhD in sociology of law, focusing on dispute resolution from the University of Wisconsin. From 2000 to 2015, I was on the faculty here at Missouri. Since then, I have been continuing to write and give presentations, and everybody teases me that I don't know how to retire because I'm as active now as I was before. So let me tell you about the underlying theory. And I developed this in response to my frustration with traditional theories, particularly facilitative and evaluative mediation. Just wrote a piece about that, and I won't go into detail about it, but I think that it's facilitative and evaluative mediation are problematic as theoretical concepts. And so I was looking for an alternative. I wanted to develop an alternative. And part of it is that, these concepts, facilitative and evaluative, and other mediation theories particularly focus on what mediators do during mediation sessions. And I've done a lot of research about early dispute resolution and the activities before the ultimate mediation or negotiation can be very important. And so the mediation practice system focuses not only on actions during mediation sessions, but also before and what mediators do afterwards. And part of what mediators do is conscious, and part of it, a lot of it, is unconscious. Particularly if you have been mediating a lot over a period of time, you develop routines and you don't even think about it. And factors affecting the systems include individual people's histories, their values, motivations, knowledge, skills, categories, and parties and behavior patterns. So think about, the 100+ mediators on this call right now. If you all mediated the same case, you would do it 100+ different ways because you have different histories. The reasons that you come to mediation, the values that you bring, the motivations, your knowledge and skills, the trainings that you've had, the kind of cases you do, and so on. So there are a lot of factors that, again, aren't reflected in the traditional theories. And the systems include routine procedures and then strategies for recurring challenges. And this graphic illustrates what I've just described here. And I'm just going to briefly note that the key thing is this orange cell, decision time by the parties. You can see that there are 3 columns here: attorneys, parties, and mediators. And the goal is to have the parties reach some decision. And traditional theory focuses on the green cell, what mediators do during mediation sessions. And of course, that's really important. It's also really important to think about the preparation for mediations sessions. And the yellow cell talks about what mediators can do. And of course, not everybody does all of the things in this graphic, but ideally, mediators would coordinate the preparation. And the row before that talks about, you can see this blue cell where the attorneys are doing case evaluation and client counseling, hopefully. They're going to learn the facts, evaluate the case, advise the clients, and retain mediators. One of the things is the traditional theories don't talk about the process of retaining mediators, which is a critically important thing. Obviously, those of you who are in private practice as a mediator think a lot about why and how people are going to retain you and how that's going to affect the kind of things that you do. So if you look at this graphic overall, you can see that there's an overall practice system that includes attorneys, parties, and mediators, and different stages, including stages before the mediation session, as well as follow-up afterwards, which often isn't addressed. So the system looks at all of those things. So this RPS Coach, Real Practice System Coach, is built on ChatGPT, and well, I have learned in the 5 months that I've been developing this about training it. So I've uploaded my materials. And so the coach is a combination of ChatGPT and my materials. And it's designed to help mediators, attorneys, disputing parties, which are all of what the folks on this call are particularly concerned about. I've also written a lot about court mediation and ADR, and a lot about legal education. And so there's a lot of material that is designed to help them, which I'm not going to focus on now. It's a work in progress. I'm working with ADR Notable. Some of you may know Gary Dornhofer, and we are working on this together. And hopefully in the not too distant future, we'll have more to say about that. So what makes RPS Coach different? I mean, one of the things is that you can do the things that we're going to show you with most AI tools. And indeed, one of the things that I did was I provided prompts to untrain ChatGPT, which is what I called it, as well as the RPS Coach, and then I asked it to compare it. And what it found was that RPS Coach provided better responses in a number of ways. It helped users provide more thoughtful, confident decisions. Of course, it's grounded in RPS theory. It has role-specific guidance. And again, it's not focused just for mediators or just for attorneys. One of the things is that it can really help parties themselves. It focuses on decision-making, which is really my main value, which is to try and help parties make decisions in their cases. I'm concerned about the horrible language that we use, which is very confusing. And so I've given it instructions to use clear, user-friendly language that doesn't have the gobbledygook of our jargon. It includes lots of checklists, and I'll talk about that shortly, and scripts and templates. What it is not, it doesn't do legal research, and it doesn't focus on arbitration. So if you wanted to know about, what the likely court outcome given a certain set of facts are, you might try a whole bunch of different AI tools, but not this one. This will help you think about it, but it won't do the legal research. And it also doesn't act as a lawyer or mediator, it's a coach. So I mentioned training. I've written a ton of things. And so I put into the permanent knowledge base, which is called these checklists for mediators and attorneys in mediation. And again, these are highlighted and in the PowerPoint that you can download that I put in the chat. You can click on those links and you can get to those checklists, which go into a tremendous amount of detail about all those things that you saw in that graphic about what mediators can do, in terms of their identities, how that affects their work, as well as what they do before, during, and after mediation sessions. A variation of the checklist is for attorneys in mediation. A lot of overlap, some differences, really primarily in terms of their ethical obligations. between mediators and attorneys. And these checklists form the heart of this tool. I also included this litigation interest and risk assessment book, which I co-authored with two wonderful Canadian law professors. They have written a lot about risk assessment, and I've focused a lot on analyzing interests, and we combined this into this book, which we referred to as LIRA. It focuses on party decision-making, negotiation and mediation, roles of attorneys and mediators, and preparation and early dispute resolution, among many other things. And these checklists that I mentioned, they describe a whole bunch of activities before mediation sessions, including conducting intake, discussing disputes and participants, arranging to receive documents. And then again, this is a very condensed version of the checklist, which goes on for 15 pages. Activities during the mediation sessions, including initiating the session, learning the history of the dispute and parties' interests, which mediators may also do to some extent before the session, help evaluate possible court outcomes, address emotional challenges, which often come up, and obviously resolve disagreements. Obviously, this is what mediators focus on a lot, resolving disagreements. All this stuff beforehand is important to make it happen. The checklists also talk about what one should do after mediation sessions, as well as helping mediators reflect after cases. So how can it help you? You can customize it with your own practice profile. You can describe the kind of cases that you deal with, your own philosophy, your preferences, and the coach can help you develop a practice profile, create a document, and then upload it so that every time you're dealing with a mediation, it knows your particular philosophy and style. You can use it at any stage, individually or in private, in joint sessions. So you can use it before a mediation session to say, hey, I'm dealing with this case coming up. Help me think through, how should I prepare? What are the logistical issues I should be dealing with? Attorneys or parties can deal with it individually beforehand. Certainly, but during a mediation, one of the values is that in real time you can use it. So if during a break you're saying, gosh, I'm having a hard time, here's the dilemma, what can I do? You can type this into Coach and get immediate ideas. And the same thing for parties and attorneys. They can do it individually if you're caucusing with the other side, or you can use it when you're caucusing with them. So you can use it in lots of combinations. One of the things that I encourage people to do for mediators is to encourage parties and attorneys to use it in advance before mediation sessions, so that when they get to a mediation session, they are ready to go. And you can use it to debrief challenging cases where things did not go as you had hoped, and you can use it to reflect and plan your practice growth. So let me give you some sample prompts or show you things that you can ask it to do. So what should I discuss with attorneys to prepare for a mediation session? How can I help parties consider the other side's perspective? Obviously, a really important thing and can be a very challenging thing for mediators to get people to understand the other side's perspective. What are some options in addition to lump sum payments in this case? Again, many mediators in civil cases are focused primarily or exclusively on exchanging lump sum payments, and that's obviously important in many cases. Some cases having some other options, either payments over time or other non-monetary options, can be really helpful. How can I encourage an attorney to be more reasonable? I'm sure that in all of your mediations, the attorneys are very reasonable, but maybe in that strange, odd case where an attorney isn't being reasonable, you can ask for suggestions about it and describe what the mediator is doing, the attorney is doing, and how you can deal with it. And then you can ask, for example, I just mediated a case that went off the rails. Please help me figure out what went wrong. So these are a few prompts. There's a document that is at the end of this PowerPoint that has a link that includes a lot more prompts that you can consider. So prompts for attorneys. Again, this is not just for mediators. Help me explain to my client the intangible costs of litigating a sexual harassment case. Help me draft a first draft of a mediation memo. Help me develop a bottom line to considering the expected court outcome, future litigation expenses, and my client's intangible interests. So, sort of what's the least I would accept as, or my client would accept as a plaintiff, or the most that I would pay as a defendant, and how can I encourage the other attorney to be more reasonable? Again, I know attorneys are always reasonable, but occasionally maybe you'll run into an attorney who isn't. And for parties, again, a few prompts. They might ask, what should I know before attending a mediation session? How should I respond to the other side's offer? Should I accept the other side's offer, or should I keep litigating? These are things that can help parties. Tips on using AI, which includes Coach, but also really any other AI tool. Bear in mind, it isn't perfect. You need to use it with care. It's improving, but I don't expect during my lifetime it's going to stop making hallucinations and having errors or not providing responses that you want. So you need to understand it's not perfect and analyze the results. You should check the accuracy and usefulness of the responses. To get good responses, you need to ask specific, well-framed questions. And bear in mind, this tool in particular is a coach. It's not a guru. It's not answering. It's not giving you the right answer. It's giving you some ideas, and the thing to get the best results from it is to engage in dialogue, not to expect that you're going to get the right answer the first time. And so Jeff and I are going to demonstrate some of that. So here's some of the resources that you may want to check out. First is this 2-page user guide, which includes a link so that you can very quickly start using it. You need to have an account on ChatGPT. Even a free account will do. This second one, this is the document that includes a lot of suggested prompts to give you some ideas of things you can do. This next one, this RPS Coach is biased and proud of it, talks about the values that are embedded in this tool, and every tool has biases, and this is making mine explicit. And then here's a link to the menu of checklists. How can you turn adversarial attorneys into quasi-mediators, basically to have them be more reasonable when you can. This one's talking about the importance of pre-session preparation and mediation, which I think is so important. And here's some information about the Lyra book. So, and then the last slide here is for information about me. So if you want to email me or check my website, you can do that. So I'm going to stop the share now because I think I'm going to need to do that to switch to the demonstration part. So I'm going to share again, and then, oops.
John, that was a terrific overview. Thank you. While we're switching over here, there were some comments in the chat, and a good general question to start with has to do with the confidentiality of what you put in to the RPS Coach. That the questions that you ask, for example, I just did a mediation that went off the rails. What did I do wrong? Well, you got to give the tool some specifics. You know, I was dealing with two lawyers, Gene Lawler and David Schraga, and you know, dig up some background information on them. And the parties were this insurance company and that insurance company and this company. And you know, you're putting in specifics in order to get meaningful feedback from the tool. But how do you put in information about what happened in the confidential mediation and how specific people behaved without violating confidentiality?
Great question. And there's a simple answer, which is that you don't provide that specific information. And mediators and attorneys and people dealing with confidential information do this all the time. You don't have to identify the person You can say there's a plaintiff and a defendant, and just you don't provide personally identifying information in addition to other information aside from names, and that's really the best way to do it. And you all do it all the time, I'm sure. You say, I've got a case where and it's a hard case, and you don't tell your colleague the names of the parties in the case. You just say it's a trucking company, it's an insurance company, it's an attorney. So that's pretty easy. While I'm here, I'm going to, someone said that the link to the RPS coach is biased. That isn't working, and I'll have to fix that, but I'm going to put that link in the chat. So did you have other questions? I haven't been following the chat. So other things you want to ask about, Jeff, at this point, or you want to highlight?
I think we should just dive into the demonstration, John, and see what happens.
Now, can you see RPS Coach here on the screen?
Yes.
All right. So let me show you a couple things here. Here's just a general description of it. Here, these are what ChatGPT calls conversation starters. And basically, because this is a tool, I describe it as a Swiss Army knife that can do a lot of things for a lot of different people. You can start with clicking on identifying what your role is. You don't have to do that. Now, before this program, Jeff came up with a hypothetical, which we're going to start with, and I've entered it here, and I'll just read it to you. I'm a mediator preparing for mediation and seek your help. I've been a mediator for many years, principally in the personal injury arena involving catastrophic injury auto cases. I've now been engaged to mediate a trucking accident, and I feel that I'm in a little over my head. There are many more parties, and the issues seem more complicated. The accident happened late at night on a curved part of a freeway. The light was about 500 feet from where the accident occurred. In its accident, a car collided with a truck. The car was being driven by a 20-year-old college student who was killed in the accident. His parents owned the car. He had been drinking beer earlier in the evening, but blood tests showed low levels of alcohol remaining. His 19-year-old girlfriend was in the passenger seat and survived, but with significant injuries. The truck was owned by Owner Co., leased to Trucking Co., and this is, well, so here in this hypo, theoretically, you could, maybe these were the names of the companies, but you could just say the truck was owned by, and come up with a pseudonym. And same thing with Trucking Co. The truck driver had been driving many hours when the accident happened. Trucking Co. claims the driver was an independent contractor, but there's a dispute over whether he really should have been considered an employee. In this lawsuit, the 19-year-old survivor is the plaintiff. She sued everybody in sight, including the driver's parents, Owner Co., Truck Co., the driver, and the government entity were responsible for keeping the freeway lit at night. They all have insurance companies involved, and there are a lot of claims for contribution and indemnification going back and forth. What advice can you give me to help conduct a high-quality mediation for these people? Now, I'm going to click the arrow to get this started, but let me just point out that this is an excellent example of a prompt that provides lots of details to help people, to help the AI tool know how to give a response. So here I'm going to click this up arrow and we'll see what it says. Now we're going to start with, this is a standard disclaimer that it is instructed to give at the beginning of every chat. It says, thanks for your prompt. I wanted you to make sure you understand what it can do and what it can't do. It can help attorneys and mediators. Sometimes it makes mistakes. You should review the output, assess its accuracy and usefulness, ask follow-up questions, and decide what to use. You should check other sources, blah, blah, blah. You can hire an attorney or mediator if you need help. This addresses that question about confidentiality. It tells people right up front, avoid using real names or other identifying information in your prompts unless it's important to include it. To maximize privacy, turn off the chat history and training setting in your data controls. to prevent your content from being used to train models. So this is designed to help you minimize the risk of disclosing confidential information. It says identify your role. If it's
John,
not,
excuse me, could you just show us where that setting is?
oh geez,
Do you know?
it would take
Or
me
should
a
we just find it on our own?
Yeah, let me
Okay.
suggest, and one of the things is that, yeah, let me suggest that you can find it on your own. It would take a little
Okay.
while. Okay, so now to your situation. You're a seasoned mediator expanding from PI into a more complex case. So here are some things. Preparation, clarify the system you're entering. Refer the mediation checklists, especially the tasks before mediation session. Now, one of the things is that, it's going to refer to things and you may not know what it's about. And so you may ask follow-up questions like, what mediation checklist? But of course, it's going to be giving you some of that information. So get oriented to the legal and factual landscape. So understand the law, map all the parties and the claims, clarify who's participating in their roles, confirm their authority to settle, and then think about pre-session communication. One of the things in terms of the language, I encourage people not to use the term pre-mediation. Of course, here it is. I've instructed to do it. One of the things is that these tools don't always do what you tell them to do, which is really annoying. So I've told it not to use the term pre-mediation because that implies that what happens before the mediation session isn't really part of the mediation. So I tell it to say before mediation or pre-session conversation. All right. So anyway, and so here it's using the language that I've told it to use: pre-session communication, explore the party's goals, ask about decision-making authority, explore possible emotional dynamics, use this to inform a mediation memo or to ask parties to use it. Use litigation interest and risk assessment techniques, which again is one of the basic tools that documents that this was trained on. And it talks about what the LIRA talks about developing a bottom line, including the potential court outcomes, the tangible costs, and a long range of intangible costs, and probe settlement scenarios beyond money. These conversations often go better in private meetings. I don't like the term caucuses, which can be off-putting, so I use the term private meetings, which I've instructed it to use. And then think about the process design. Consider a two-stage mediation and early sessions to clarify the facts, and a second session possibly to settle issues. Explore the use of visual aids during the session. So all of what we're talking about up until now is planning for the mediation, and then for the mediator's checklist, be prepared to understand their bottom lines, see if their interests include some of these non-monetary issues, these intangible issues such as apology, policy change, non-disclosure, consider emotions and possible decision fatigue, and then after the session, debrief and reflect what worked, what could improve, and so on. And then, of course, it always ends with a question. Would you like me to help you with this or that? And you can say, yeah, that would be great, or you can just ignore it and ask the next question. So this is an illustration of a response, and it should not be the only response. Now, Jeff and I are going to have a conversation here as if we're in your mind and we're thinking, okay, what am I going to do next? How am I going to use this? And then we're going to ask some follow-up questions. So Jeff, as you reflect on what you've just seen in this response, what would you want to know next from Coach?
Well, I think what I'd like to know next from the coach, John, is what can I anticipate will be the most significant issues to resolve in this mediation? And does the coach have any advice as to the order in which those issues should be addressed in the mediation?
Great. And so you can be thinking about this. Now, one of the things that I recently learned about is that you can actually dictate a thing. I would normally type it in, but we're going to demonstrate the dictation, which should work here. And so I'm going to click this dictate button, and then I'm going to ask Jeff to essentially repeat what you just said. And you'll see it does this voice recognition. It will put it into text. So Jeff, are you ready? All right.
Thank you, Coach. While this is helpful, it's pretty general. Let's please get more specific. What do you anticipate will be the most significant issues to resolve in this mediation? And do you have a recommendation as to how to sequence these issues in order to give these people the best chance at a settlement that will satisfy them?
Great. Okay, so I click this and you'll see momentarily, hopefully, that it will, looks like it's working on it. It will, there you go. And you can see it's transcribed Jeff's, and it does a pretty good job of voice recognition. So it's transcribed the question, click up and we'll see what it says. It always says, that's an excellent question. I've never had it say, that is the stupidest question I've ever heard. Where did you go to law school? Never.
You know, John, I've sometimes asked ChatGPT, you seem a little patronizing to me. What would be an example of a lousy question?
Well, one of the things that I've done is I've used this actually for personal conversations, what I call friendly chats. And I say, you know, let's have a conversation about all sorts of personal things, say, and I want you to be supportive, but also candid. So not this sugar-coated stuff. And sometimes it does a good job. All right, so let's take a look and see what it says. An excellent question, Jeff. Your request for specificity is exactly on point. Here are key clusters of issues, likely significant issues to resolve. Liability and apportionment fault. Primary question, who is at fault for the accident? How much fault belongs to each defendant? Key challenges, disputed employment relationship. Insurance coverage, stacking and indemnity. Damages for the plaintiff. Non-monetary and emotional issues. Recommended sequencing strategy. Start with structure and process, address plaintiff's damages first, then explore liability and fault allocation, parallel track indemnity and contribution, insurance and payment mechanics, address intangible and emotional issues, tips for managing complexity, use checklists, consider two-stage mediation. Now, one of the things I would just say about this and every other response, you may find some of this helpful. A lot of it is stuff that I think mediators would say, oh yeah, this makes a lot of sense. What I find helpful about responses like this is it's pretty thorough and detailed, and it covers lots of things that you might not think about right off the top of your head. So you can look at this and say, yeah, I like some of this, that makes sense, or that doesn't make sense. So Jeff, what's your, and of course you didn't have a chance to read all the detail, but from what you read as we scrolled through it, what was your reaction and what would be your next question?
John, let's scroll back up to the part on liability.
Okay,
No, I think it's down a little.
this one, or do you want insurance
I
coverage?
think there was one down a little farther, wasn't there? When it comes to sequencing. Here, address damages first, then go down. It says, then talk about liability.
Okay.
Okay, so consider a range building approach. What, okay, so let's you want to turn the microphone back on?
Sure.
Thank you for this. With respect to exploring liability, I am concerned that the parties on the defense side will just start pointing fingers at each other and claiming that the other defendants have all the responsibility and that they have none. What are some practical tools I can use to get beyond that sort of unproductive finger pointing?
Excellent. I'm sure this happens all the time when you have multiple defendants. Okay, so let's see what it says. One of the classic traps. One of the things about this Lyra book is that it includes, which is published by the ABA, it includes lots of questions that you can ask like these. And so I think these actually may have come from that book. So ask, this isn't about blame, it's asking about your prediction of verdicts, normalize shared exposure. So you could, oh, now this is interesting. I don't know if you all do this. Draw a shared exposure matrix. One of the things is it does all sorts of stuff that I haven't trained it. I wouldn't know to do this, but it has picked up somewhere, probably from ChatGPT generally. Explore range building, not necessarily final allocations. Use mediator proposals for allocation. Focus on plaintiff settlement demand first. Use time pressure strategically. Validate but redirect. Acknowledge each party's perspective without validating their stall. It's a fair argument you raised at trial, but for settlement, the question is, what are you willing to pay to avoid the risk? You protected your legal position here. Let's shift to what you're willing to invest to close this file. So Jeff, what's your reaction? Again, I've scrolled through this. You haven't had a chance to read it carefully. What's your take on this?
It's helpful, John. It's helpful. I have another question I want to ask.
Excellent. Great. This is
Okay. Thank you. This is very helpful. One of the defense attorneys has a reputation for belligerence and trying to bully not only mediators, but also co-defendants in situations such as this. I have never worked with him before, but I have heard about him from other mediators. He represents the trucking co., which was the company that operates the trucks, which I believe is likely to have very significant liability exposure in this case. Do you have some practical tips on how to deal with a belligerent attorney who I believe at day's end will have to belly up and take significant responsibility for his client?
one of the things that I've found really cool about working with Coach and ChatGPT is that AI has developed to the point where it understands idioms. So for example, to say belly up, in the earlier iterations of AI, it wouldn't know what that means, but it understands idioms incredibly well. So here it is, Jeff's question, and let's just see what its answer is. And you can see that, I mean, here it's taking actually a little longer than usual. You're anticipating a challenging dynamic. Again, great question, Jeff, as it compliments you. Practical tools for managing.
You sound like ChatGPT, John.
Exactly.
Excellent question.
Well, that's my point. That's what it's saying. You're asking a good question. Set process expectations firmly but professionally. Establish toning guardrails. I know this is a tough case, but there's a lot of frustration all around. I'm not asking anyone to give up advocacy, but I'll keep us on track that's forward looking. What I've seen work best in cases like this is a collaborative focus on managing risk, not blame. Don't let them dominate the room. Structure your environment. Limit joint sessions. Of course, a lot of you probably don't use joint sessions at all. Use short, focused private meetings. Again, caucuses. Use your notepad or screen as a pacing device. Let me capture that and loop back. Acknowledge and then pivot. Again, standard. A lot of this stuff is standard mediation 101, although going into more detail and doing it more extensively. When he comes at you with sarcasm, skepticism, or pressure, use a validate and pivot move. I hear your frustration. That said, your client has real risk. Use risk of isolation strategically. Use numbers and visuals, not rhetoric. Belligerent attorneys often rely on emotions and posturing. Shift the conversation to concrete risk framing. Privately confront role conflict without ego clash. Have a backup strategy. Plan B exit path. Why this matters in your case. Trucking company has most at stake. Attorney whose positional aggregation masks client vulnerability, which is probably a common dynamic when you have belligerent attorneys. You can use his desire not to be left out. Would you like a belligerent attorney briefing card? One pager can keep on hand with cues, framing language, and sequencing reminders. Happy to generate one for you. Do you want to ask more, Jeff, or
Yeah.
Go
Yeah, I've
ahead.
got a couple more, and then why don't we open it up to questions and answers?
All right. Go.
Thank you. That was very helpful. I have another question. Since I have never done a case quite like this before, I am curious to know whether there are any specific terms of art or terms of jargon with which the parties will expect me to be familiar so that I do not appear to be naive or stupid.
A great question. I'm sure that a lot of you are, will deal with cases, where you haven't dealt with the subject matter before. A good question to ask in advance. Let's see what it says. Watch for control test lease agreement, dispatch authority, right to terminate 1099 status. FMCSA compliance, Federal Motor Carrier Safety Administration, accident and liability damage, language, visibility claims, contribution indemnity, tender reservation of rights, policy limits, excess umbrella, high-low agreement, Medicare set aside. And look, I mean, this is just going on. Mediator tip, language to signal competence without overplaying. Is your indemnity position tied to the legal terms or course of performance and so on? One of the things is that in something like this, in response to this, you might say, well, gosh, tell me more about the Medicare set aside or, any of these things. So this is just an invitation to ask more questions. I see that David has his hand up, and maybe this is a good time to answer questions. So with that, I'm going to stop the share if that's okay, and we can just have a conversation from here.
I was going to ask Jeff to ask one more question of the model.
Okay.
So I want to leave a few, thank you, David. I want to leave a few minutes for the questions of others. So if you have a question, please unmute yourself or put it in the chat.
I guess my question was going to go to how to use the tool to ask about issues involving policy limits or demands in excess of the policy. I know, Jeff, you're the master of dealing with these types of situations with multi-party cases.
Well, I mean, you could just ask that question and you could see the sort of things that that it would do. So, I mean, that would be a great one. I'm looking at the chat now. Valerie says, I'd like a belligerent attorney briefing card. Can I ask AI to generate it for us all? Are there questions? I mean, one of the things is we could go through the chat and I could address those, or if people want to raise their hand, I can do that.
Let's have people, if people just want to unmute themselves and ask their questions, that's probably the easiest.
Okay.
I am wondering about the whole notion of information being online because you're using Chat GPT.
So is it the privacy concern? Is that what you're wondering about, Catherine?
Yeah, it's a combination of privacy, but also like if I'm saying something like, I'm not that experienced in this area, I don't want my clients to see that. I mean, that's privacy, but it's a different kind of privacy. It's not, now I want to protect my privacy, not, or my reputation, not just the client's information.
Well, I mean, in some ways, it's, I would say, much like I mean, it sounds like you're thinking about what you would say if you're doing it in front of clients. Is that your question?
Well,
No,
John, I think, excuse me, I think it's more, could somebody go in and ask, is there any record of Jeff Kitchaven having prepared for this mediation using this tool? And if so, what did he do?
right, you've got it, Jeff.
I am not, my understanding is that it can't do that, but I'm not a tech expert. I saw Jim Malamed was on the call, and there may be others who can actually answer that question.
John, maybe we should just ask ChatGPT itself.
Well,
Just ask the tool.
I've done that, and again, the question is if you believe it. So let's just see. Catherine, do you want to dictate the question?
No, let Jeff do it. He does it well.
Okay, you ready, Jeff?
Okay, let's go.
Go.
I am concerned that the parties to the mediation may somehow be able to retrieve our conversation through clever prompts of their own using this tool or some other AI tool. Do I have anything, is there any basis for my concern?
Conversation is private. Not even another user of the AI system can access your chats through prompts or hacks. Caution, chat history can be used for training if you leave the default setting on. And I described how you can, and here it is, talking about how you can turn it off. Turning it off ensures your conversation is not stored long-term, not used to train future versions, not accessible to anyone else. Here it tells you how to do that. Even if it's on, no other user can prompt engineer their way into your content. Bottom line, what you can do now, set that setting. And of course, you saw that in my initial disclaimer, I told people how to do this. So I'm conscious of and concerned about having people protect the confidentiality. So hopefully, I mean, again, I'm this is what it tells me. I'm assuming it's telling me the truth, but I don't know. David has your hand up. David, what were you gonna
Yeah,
say?
John, I mean, it's clear from your presentation that it's really a tool to facilitate preparation and dialogue and inquiry. I wonder, how do you talk to parties or the lawyers about, you encourage them to potentially use it themselves, and how do you manage that tension perhaps between them being overly reliant on the tool or using it for predictive purposes versus the real work a mediator does in a mediation to bridge the gap between the parties and use the mediator's toolbook in a sense to get a case settled, not just the AI tool.
Sure. There are a couple of things in there, and I may not remember them all. So if I forget some, please ask again. I would say it's certainly good for preparation, and it's good for dealing with things in the moment. So some of the questions, for example, Jeff's question about dealing with a belligerent attorney, that is a question that a mediator could ask in the moment. And in terms of having people rely too much on the AI tools, that's a much larger issue. I mean, part of it is what's called AI literacy and having people learn what to expect and what's realistic and what's not. And that's in some ways maybe beyond what mediators can do in preparing clients for it. Although if you look at the 2-page user guide that I provided, that provides a useful overall sense. And in some ways, I guess maybe what you're getting at, David, relates to an overall sense of anchoring. So, I mean, they could look at the results from AI, from this tool or litigation analytics tool or all sorts of other sources and say, well, I'm really confident that I know what the results are going to be. And so I'm right and you're wrong. And so in some ways, that's a particular example of a general dynamic that mediators encounter all the time where parties express overconfidence and maybe unrealistic confidence in their positions. Were there parts of your question that I didn't address?
No, I think that gets to it, and I think it sort of goes. The heart of the question is how does the mediator just differentiate the real tools and the role of the mediator in the process? You know, that to bridge the gap between the questions and the data and resolution.
And that's what mediators do, and what tools like this do. It doesn't tell you the right answer or tell you what to do. It gives you lots of ideas, and it's up to you as the mediator or you as the user of any AI tool to decide whether you want to follow some of the suggestions or not, or modify them. So there may be some aspects of a response that sound good, but you want to tweak it some. I use this tool primarily for writing. I write a lot. I continue to write a lot, and it helps me write. And I will often it'll get a response, give me a response, and I'll say, I like part of it, but I'm going to use something else. I see David has your hand up, so I want to have you ask your question or make your comment.
Thank you. When you were talking about privacy earlier, Jay Williams put in the chat, quote, most of us who subscribe to ChatGPT are operating in a, quote, private environment, unquote, that is not open to the public. Quote, that was Jay Williams' comment. And I think it's important to address the fact that, or to ask the question, are you subscribing to ChatGPT and that's the domain you're working from? Or are you using the free version with this tool you have created?
In order to create a tool, you need to have a paid version, and so I have. For users, you don't need to have a paid version. You need to have a version which can be a free version. And presumably the privacy controls would be the same in both the free and the paid versions, although again, I can't tell you.
In the free version, I can tell you nothing's private. Whatever you put there will be out in the public domain, and other people can see it and can access it. I cannot speak to the a paid subscription version because I don't use one at this point in time. Well, and I just kind of dabble with the free version. But the free version is not private. Anything you put out there, anybody else can see in the free version of ChatGPT. I'm done. Thank you.
So here I've asked this question, and again, you can see if you believe the answer, and you should always be skeptical. Great question. Oh, look at that. I didn't know that. By default, your conversations may be used. But there's no way for another user to prompt their way into your account. And even in the free version, you can still turn off the chat history and training, it says.
That's a new feature because when I started using it, that feature wasn't there. That's interesting.
Well, one of the things that is true about AI, and I'm confident of this, is that this is a moving target. I mean, they are constantly developing new versions and variations of the versions. So ChatGPT today is different than it was yesterday, and it will be different than it will be tomorrow, and maybe, in an hour from now. So hopefully at some point things will stabilize. You can think about other technologies in the past that have developed, and in the beginning they were uncertain, and then over time they've kind of stabilized. And I imagine that's probably true for AI and ChatGPT as well.
John, I hate to bring the conversation to a close, but the clock on the wall says it's time. I want to thank you very much. This has been a most stimulating and educational conversation. We've had as many as 125, over 125 people online, so it's been one of our biggest crowds. I really hope people are motivated to contribute to the food bank for Central and Northeastern Missouri. And we'll put the link once again up in the chat. Please, my friends, contribute to that food bank if you're able, or any other food bank in your area or one that's otherwise important to you. It's been a tremendous presentation, John. Thank you so much. And with that, we are complete.